Good afternoon, everyone. Thank you for joining us today for the Florida chapter of the American Planning Association's overview of the 2020 legislative session. I'm Wyatt Bowers. I'm the president-elect of the chapter, and we'll be introducing our other speakers in just a second. I'd like to make a couple notes. First, thanking all of our annual sponsors for their continued support: Theriac in Spain, the Emerald Coast Regional Council, VHB, Wade Trim, Hopping Green, and Sam's. As you all probably just heard, everyone is on mute in listen-only mode. There is a question box in the panel on the right side. Please go ahead and enter your questions if you want, and we're going to hope to get to those before the end of the broadcast, and we'll stay a little bit longer, a few minutes if need be. I'm sure most of us are getting used to doing a lot of these webinars and Zoom calls and distance learning from home. I hope that everyone is healthy and staying safe. I am also getting used to doing a lot of these. In fact, my day is pretty packed today with webinars and Zoom calls. This one is super popular. We have nearly 300 people that have registered for today's call. We are going to be recording the session. It is being recorded right now. And will be available later for distance learning. The slides will be posted online on the chapter's website. And for those of you that are AICP, there is information at the end on the CM credits. So, as I said, my name is Wyatt Bowers. I'm the president-elect. And with us joining me today are Lester Abinger, Florida Lobby Associates. He is our legislative liaison, and Alex McGee, our chapter executive director. So a little bit about APA Florida's legislative actions and the things that we regularly do. First off, we have a legislative policy committee that, as president-elect, I'm the chair of. It is comprised of representatives from every section as well as at-large members. They serve a 2-year term. Additionally, Alex and Lester work very hard throughout session to provide regular updates through the bill tracking report and legislative reporters. And if you don't get those, I encourage you to sign up. And they're chock full of information coming out during session, as well as scattered a little bit throughout the year. And then we also host a public policy workshop. I think this year was our 18th annual in Tallahassee. So this year it was on February 5th. And we bring in various speakers to talk about hot topics, as well as what is going to be happening during the legislative session. Quite often it happens, the workshop occurs before the legislature starts. In the case of this year, it was in the middle of session. Next slide. Something that we were able to do this year, and it's something that we're kind of trying to gradually build up to, we were able to go up to Capitol Hill, and members of the Legislative Policy Committee joined me, and we went to the Senate chambers, and we were recognized on the Senate floor by Senator Bobby Powell. He also put forth a resolution for Community Planning Day. And what we're hoping to do is to take this now back to your home districts, and in the fall, do what we're calling planner days in the districts, where members of each section will meet with their legislators ahead of the 2021 session to really try to affect some change and get on the radar before they go to Tallahassee for committee meetings. Next. Now, I just mentioned kind of what happens at the chapter level. At the national level, there's the Planners Advocacy Network, which helps to shape APA's policy and advocacy work. I encourage anyone who is not a member of that to, again, go online to planning.org and join that. The link is there. You get regular policy updates coming out of Washington, the opportunity to influence federal and state policy outcomes. Also, a really nice advantage is special registration rates for APA's annual policy and advocacy conference. What you see at the bottom right are some of the APA Florida members who joined this year in DC, where we went to meet with our local and state legislative officials in DC. And with that, next slide, I believe, is turning over to Lester and Alex.
Great. Excuse me. Thank you very much, Wyatt, and certainly echo your comments. We hope that those of us or those of you who are on the line are safe and sound, your families and colleagues as well. The slide that you see before you shows the total number of bills filed and the mere 207 bills that pass. As we've discussed before, this is a system that's deliberately designed to make it difficult to pass bills and to promote compromise. These statistics are fairly typical of the last 3 or 4 years. Usually somewhere 200 plus or minus bills end up passing. So a fairly typical session in terms of the number of bills. The coronavirus, as you all know, it epitomizes what is known as a black swan event, which was a term attributed to statistician Nassim Taleb and defined as, quote, a rare, hard to predict, high impact event beyond normal expectations. And we've certainly seen that. And I say that as a caveat before we begin the discussion of the budget, because the budget now, in consequence of the coronavirus in Florida, is subject to possibly radical changes. But what I'm going to talk about is what we know now, and we will certainly keep you apprised, as Wyatt mentioned, through our networks and publications and emails as any changes occur. The budget, again, as we've discussed before, is the only bill that must pass. And this year it resulted in a extension of the session for several days in order to comply with what we call the 72-hour rule, which requires that the budget be published and available to the members and the public for 72 hours before they vote on it. This year's budget is a record $93.2 billion. The House had proposed a budget of $91.37 billion, and the Senate proposed $92.83 billion. One of the initial effects of the virus was an effort by the legislature to boost the state's reserves by $300 million. So there's now about $3.8 billion available in the state reserves for circumstances such as these. The governor's priority of a teacher pay increase was adopted at a cost of $500 million to raise the minimum teacher salary to $47,500. The governor had initially proposed a $900 million program for that, which consisted of $600 million in pay raises and another $300 million in bonuses and performance incentives. Also of note in the budget is a 3% state employee pay raise, the first since 2013. In terms of issues, budget issues of consequence to the APA Florida members, Florida Forever was funded at $100 million this year, a major significant increase from $33 million in the 2019-2020 fiscal year. The governor had proposed funding the program at $100 million. The Senate budget had $125 million. The House budget had $20 million. So the $100 million was adopted, and I think the grassroots lobbying on behalf of the Florida Forever program was very, very effective. The chairman of the House Appropriations Subcommittee with jurisdiction over natural resource appropriations when the budget compromise was reached, said publicly, the emails can now stop. So your emails on this issue made a big difference. The $100 million is broken down. There's $67 million for land acquisition, what some of us think of as the traditional Florida Forever funding, $8.7 million for the Rural and Family Land Stewardship Program, which is administered by the Department of Agriculture, $12.3 million for local park funding, $10 million for the Florida Communities Trust Program, and $2 million for the Working Waterfronts Program. APA Florida participated in the Florida Forever Coalition. We think that the $100 million appropriation in this budget is a good first step, but we need to get back to the historic levels of $300 million or so, which is consistent with the Amendment 1 expectations. Similarly, and in a virtually unprecedented fashion, the affordable housing program was fully funded at $387 million. There was no sweep of the trust fund. This trust fund has been swept over the past 15 years or so of more than $2 billion. So again, this is a great victory for affordable housing. We, APA Florida, participated in the Sadowski Coalition, which is the advocacy group for affordable housing in Florida. Unfortunately, Senate Bill 306 by Senator Mayfield and a similar House bill by Representative Killebrew to permanently ban the trust fund sweeps was not adopted. But again, an unprecedented level of funding, $387 million for affordable housing. Visit Florida, another controversial issue. The state's tourist promotion agency, and certainly a sign as the virus began to emerge that Florida's budget for tourism promotion assumed a much greater importance. The governor had proposed $50 million in funding. The Senate proposed $50 million, and the House proposed no funding for Visit Florida. At the end of the day, it was funded at $50 million and reauthorized through October 1st, 2023. This had been a target of the House leadership, but I think they were swayed by the emergence of the virus. In terms of tax relief, the package was significantly reduced, again, at the last minute in the context of the pandemic. The final package is some $47.7 million, which includes hurricane and school sales tax holidays. The governor theoretically has until the 30th of June, the end of the state's fiscal year, to tackle the budget and exercise his veto authority. The timing will be contingent on when the legislature formally conveys the budget to the governor, which then will trigger the 14-day clock for action. And I'm sure, as in past years, there's a lot of behind-the-scenes coordination between the legislative leadership and the governor's office as to when the budget will be formally submitted to the governor, and which also is affected, like everything else, by the impact of the pandemic. In terms of some major issues that the legislature addressed during the 2020 session, abortion rights by effort by conservative members to require parental consent for minors. The bill was not passed. We talked about the budget with the teacher pay increase, the 3% state worker pay increase, funding for Florida Forever, Visit Florida. A lot of attention, and I'm sure many of you saw the press coverage about the egregious mismanagement of the Coalition Against Domestic Violence. The legislature stripped the coalition of its role as manager of funds for domestic violence centers across the state. And they are still seeking testimony from the executive director to discuss her salary challenges. In terms of the COVID-19, as I said, they added $300 million to reserves and reduced the tax cut package. Education, a huge part of the budget, as we discussed, a teacher pay increase and an expansion of private school vouchers to make 20,000 more students eligible for those. There was no school safety bill implementing the Marjorie Stoneman Douglas Commission recommendations. We've discussed the environment, healthcare, another major issue, a priority of Speaker Oliva, and there was expansion of practice parameters for pharmacists and advanced registered nurse practitioners. There was some effort on immigration reform, again, a priority of the governor, and he wanted extensive use of the E-Verify system by employers. That ended up being weakened, and it applies now, the E-Verify mandate, only to government employers, and it is optional for other businesses. We're going to talk later on as we go through the bills about the status of the various preemption bills where the state efforts to preempt local authority on a wide variety of issues. But there were more than 100 of those bills, and we're pleased to report that not very many of them passed. In terms of issues that didn't make it to the finish line that are of consequence, I think, there was an effort to repeal the Constitutional Revision Commission. The House voted to do that, but there was no Senate vote. Gambling, we're still waiting for a deal with the Seminole tribe, which would result in some $700 million of extra revenue. But as I said, the negotiations are ongoing, no deal yet. There was an effort to repeal no-fault insurance, which didn't make it to the finish line. There were no votes by the full House or the Senate. There was a proposal to move the Office of Energy from the Department of Agriculture and Consumer Services to the governor's office, largely political in my view. That bill did not pass. An effort to provide some sunshine law exemptions for presidential searches at state universities and colleges did not pass. And as I said, for the first time since the tragedy at the high school, Marjorie Stoneman Douglas High School, there were no broad bills on school safety. Similarly, a very progressive, constructive effort in the Senate on sentencing reform, badly needed criminal justice reform, had strong support in the Senate, but not much help in the House, and that did not pass. I mentioned the issue of school board term limits, which were the subject of a lot of discussion. It would impose 8-year term limits on county school board members, but it is, in my view, a classic illustration of the urge for preemptions by the legislature of local authorities. There's a problem, some would say, in one county with one recalcitrant school board member, and so the proposed solution was to impose term limits on all school board members, and that bill did not pass. Alex, are we ready to take up the bills, or do we want to
No, that's fine. I think we're ready
continue
to.
with this?
No, I think we're ready to go to. Let's talk about a little bit more about what didn't pass. As Lester said, the system is set up so that many of the bills don't make it through the legislative process. And this year, only about 11% of the general purpose bills that were filed actually passed, and only I think it was 23 bills out of the over 250 bills that we as an organization were following actually ended up passing. So that means 89% of the bills that were filed didn't pass. So I just wanted to talk a little bit about some of those that I think might be of interest to you. As Lester said, there were over 100 local preemption and mandate bills. What would a session be without our perennial vacation rental bill? We had
Right.
2 filed this year. But I think the governor came out sort of towards the end of the session, and he was quoted in the press as not being in favor of these bills and feeling that a lot of the issues that testimony was bringing up during the committee meetings were issues that really should be handled at the local level. And so the Senate bill died in its last committee, and the House bill actually made it out of committee but was withdrawn on second reading. And I think the governor's position had something to do with that.
I agree, Alex. That's a very cogent analysis of that issue, but expect it to be back. This is year 6 or 7, as Alex mentioned, and we have been steadfast in our opposition to that.
So then I wanted to just briefly talk about the Burt Harris Act bills, Senate Bill 1766 and House Bill 519. And there were similar bills filed last year. They failed to pass then. But the bills, when they were submitted this year, did a couple of things that really triggered concern. One was it would presume that when a settlement was reached under a Burt Harris Act conflict, that similarly situated residential properties were entitled to the same settlement. So there was a presumption that if your neighbor reached a settlement and you were a similarly situated residential property, you were entitled to the same settlement. The bill also made changes to make it easier to challenge local regulations. The Senate bill died again in its last committee. The House bill was actually passed by the House. It did in the end delete the similarly situated residential properties clause, but it died in the Senate. And I know, Lester, you spent a lot of time on this bill. If you had any other context you wanted to add.
We did. We spent a great deal of time on it, and we successfully added an amendment in the Senate, as Alex just alluded to, that I guess you would say made this less egregious, if that's a fair way to describe it. Also, in the context of this bill, which is a very, very complicated issue, Wyatt provided great leadership in soliciting comments and suggestions and analysis from the Legislative Policy Committee that I used in my meetings, particularly with the professional staff in the House and the Senate, and with some of the members. The Florida League of Cities deserves a great deal of credit for their work on this bill, And I want to particularly thank Susan Trevarthen and David Theriak of our LPC, who provided detailed, extensive, perceptive, persuasive analysis that I was able to share with the people down at the Capitol. So thank you very much.
So there was another bill that I hadn't seen before that was filed this year dealing with home-based businesses. It would have authorized a home-based business to operate in any residential zone, and it would have restricted local government from regulating those businesses in a manner that was different from any other business in their jurisdiction. The Senate bill actually was never heard in committee. The House bill, which was filed by Representative Donalds, made it through committees but was withdrawn from consideration on second reading. But I would think that this might be a bill that we would end up seeing again next year.
I agree.
And then the last bill on the slide that I wanted to talk to dealt with the restriction of building design elements applications. So Senate Bill 954 and House Bill 459 would have restricted the application of building design elements to single or two-family dwellings unless they were dwellings that were listed in the National Register, listed as a contributing structure to the National Register District, designated under a local preservation ordinance, or the regulations were adopted to implement the National Flood Insurance Program. So here again, the House bill was never heard in committee, but the Senate bill wasn't heard in committee, but the House bill passed through committee and was on the House calendar on second reading and was withdrawn from consideration at that point. But the interesting part about this is that several other states, such as Georgia, have had similar bills also filed this year. And Wyatt, I know that you've been talking to National about this issue, if you have something you wanted to add.
Yeah, real quick. First off, Lester also was very helpful in this in trying to help us understand why the bill was filed and by who and what their motivations were. It turns out through our national network of legislative leaders, we found that several states had virtually the identical text of the bill. And there are a couple of other bills that are kind of in that same vein. And so there are national organizations, in this case, ALEC, the American Legislative Exchange Council, that provide model legislation to people to look at. Georgia was able to defeat theirs again this year. There are a couple of states that this has passed in past years, but it is the advantage of being able to collectively meet with our counterparts in other states.
And this bill will be back. Count on it.
So then there were some economic development bills that we were following that didn't pass, micro business assistance, targeting economic development assistance to areas affected by Hurricane Michael. There were, as Lester had said, there was two bills to prohibit sweeping the Affordable Trust Fund dollars that failed to pass. There was also a couple of bills that would have provided a tax reduction for the provision of workforce housing that also did not pass. And then when we look at environmental bills, Lester had mentioned the bills that would have required the specific annual appropriation to Florida Forever that didn't pass. We did have a bill this year that would have required comp plans and plan amendments that applied to certain lands within or near the Everglades Protection Area to follow the state coordinated review process. Those did not pass. But it's interesting, after years of not being able to say climate change and climate change not being able to be something that was actually talked about, this year it looks like that feeling has been altered. The Senate had actually adopted a resolution that stated that the legislator intends to adopt policies focusing on, I'm going to quote, resiliency efforts and appropriate infrastructure which prepare Florida for the environmental and economic impact of climate change, sea level rise, flooding, and policies relating to clean and renewable energy, unquote. And when I was putting together the slide after I had remembered about that resolution, I looked at the 4 last bullets: the renewable energy, the annual climate health planning, the fiscal responsibility, and the research program. And all of those, you know, are an outreach of the desires that were reflected in that resolution. We did, one bill that we will talk about later on that did pass was a bill that does require sea level impact projection studies when state dollars are used to do construction in the coastal building zone areas. So we'll talk a little bit about that. That is one bill in this font that did pass. And then I just wanted to point out some other ones that I know some of our members were interested in. Lester mentioned already the Constitution Revision Commission. There was a bill to create a minimum criteria for civic literacy that would have been incorporated into a high school's curriculum. That did not pass, but I did want to point out that APA Florida is a member of the Florida Civic Advance Coalition, which is a coalition of organizations and nonprofits from around the state that are looking for ways to improve and increase civic engagement within the state. Another bill that didn't pass but did raise the concerns of some of our members who are transportation planners were bills that would have restricted the use of those yellow rectangular rapid flashing beacons that you see at crosswalks. Those did not pass. And then for people who are involved in education, there were a number of provisions and bills related to charter schools that didn't pass this year. So let's talk about what actually did pass, and let's see what bills were in that 11% that made it through the legislature. The first bill I'm going to talk about is Senate Bill 410. I think this is probably considered to be the growth management bill for the year. It has a number of different parts to it. The first part on the slide is deals with the requirement for a specific property rights element in local comprehensive plans. And Senator Perry, who had filed this bill, has filed these provisions in bills every year since 2014.
Right,
So
he filed them as a House member and as a senator, and through the, again, analysis from our Legislative Policy Committee, we tried to explain to them that the current law protects property rights, and there may not be a need for this element, which is going to result in some cost to local government.
Yeah. So the property rights element would be required to be included in the next plan amendment process or by July 1st, 2023, whichever is earlier. It does provide a model statement of property rights, and the local government is allowed to just take that model statement of property rights and incorporate it as its property rights element in its plan. It does include 4 acknowledgments that have to be considered by local government, though. It has the right of the property owner to possess and control the property, the right of the property owner to use and maintain and improve his property, the right of the property owner to privacy and to exclude others from the property, and the right of the property owner to dispose and give away through sale or gift the property. the list of rights originally did include one that dealt with the right of the property owner to the quiet enjoyment of the property to the exclusion of all others. But that right ended up being amended out through the course of the committee process.
Just as a footnote there, the quiet enjoyment provision relates back also to the short-term vacation rental issue. It shows how some of these things are interlinked and oftentimes at cross purposes.
The next big section of the bill deals with really charter counties and the cities within them and their plans. And it creates a new section under 163-3167 that provide that one, a county cannot adopt after January 1st, 2020, any form of restriction that serves as a limitation on a municipality from establishing land use and zoning in the lands located within that city, unless the municipality through its own ordinances adopts and imposes these restrictions. So as you know, the Florida Constitution requires charter counties to determine which regulations will prevail if there is a conflict. And this provision seems to conflict with that constitutional requirement. It also states that the county can't limit a municipality from deciding the land uses, density intensities on lands that are annexed into a municipality unless it's in compliance with 163-3167, which is the comp planning subsection. It does say that these provisions don't apply to a charter county with a population in excess of 750,000 as of January 1st, 2020, and which has charter provisions that govern land use and development that apply in all jurisdictions within the county.
And this is of great concern to the counties because, again, it's a classic preemption.
Yeah, and it creates sort of a arbitrary distinction between the large charter counties who none of these provisions will affect and the smaller and the medium-sized ones who it will affect. And it's like an arbitrary population threshold to do that. So then the bill also has a number of what I'm calling miscellaneous provisions. It includes a provision that directs DEO to give preference when awarding its technical assistant grants to counties that have a population of 200 or less in the cities within that county. The TA grants would be for assistance in conducting those land use studies that the MCOR process requires around the interchanges. And I think you'll see that there's a trend in some of the other bills that we are going to be talking about where there is, the legislature is giving a preference for funding to items that are related to MCORs. Then there are two provisions that deal with different kinds of development orders. The first provision allows a party who is part of a development agreement and the local government to amend and cancel the agreement without the consent of other parcel owners unless the amendment or cancellation modifies their uses or their entitlements. And it also allows essentially built out DRI agreements that are effective, that were effective on or after April 6th of 2018 to be amended so that they can exchange land uses. You can switch one land use out to the other. The only qualification is that you have to demonstrate that the exchange will not increase impacts to public facilities. And then there's a provision that requires DOT to give, if they find they have property they were going to use for a transportation facility, it's no longer needed. They have to give the right of first refusal to the previous property owner. And then the final section deals with permits in the public right-of-way. And permit requirements in local public right-of-ways has been a big issue for local government for several years. In 2017, the legislature streamlined the local permitting process for small wireless facilities that would be in local government's right-of-ways. Last year, Senate Bill 1000 expanded these streamlined provisions to apply to all communication facilities. And this bill, if you read what's on the slide, now opens up these specified streamlined timeframes to any utility using seeking to use the local government's right of way. So it's been over time an erosion of the local government's ability to process these in I guess the League of Cities and Association Counties were saying in a manner that would give them time to do the reviews that are necessary. So this bill would be effective July 1, 2020. It hasn't been submitted. And I do want to say before I forget that all of the bills that we're talking about from this point forward need to be sent to the governor for his action. I looked today and it doesn't appear that any bills have been submitted to him since March 11th. And I think that this is obviously a result of the legislature trying to work with the governor because of the coronavirus and the issues and the time that he has to spend on that. But all of these bills still need to be sent to the governor, and once they're submitted to him, he has 15 days to decide whether he's going to approve them, veto them, or just let them take no action. And this bill, Wyatt, I think you have some context on.
Yes.
Yes.
Thank you. From the time it passed, again, some of those things, for example, about the charter counties and that issue regarding land use was something that was put in at the end of session after all the committees had gone through the process. Primarily because of that part of the bill, several organizations, including Thousand Friends of Florida, the Association of Counties, as Lester mentioned, the Florida Stormwater Association, are recommending or requesting that Governor DeSantis veto the bill. Our chapter met as the Legislative Policy Committee and had some discussions, and then as a legislative leadership team last week, and we are drafting our letter, which will be going to the governor in the next few days. But as Alex has noted, the bill has not even been submitted to him yet. So we are requesting that the governor veto this bill.
Okay, thanks, Wyatt. So the next bill I want to talk about is an impact fee bill. It's Senate Bill 1066, and it does 4 major things. It says that new or increased impact fees can't be applied to current or pending permit applications unless the result is to reduce the total mitigation costs or impact fees imposed on an applicant. So it is only if you're going to the new fees would reduce the costs, could it apply to something that's already in the process before the effective date of the new ordinance. It clarifies that local government has to credit public education facility contributions, irrespective of comp plan policies or charter provisions or resolutions. It does now provide that impact fee credits are assignable and transferable at any time from one development or parcel to another within the same impact fee zone or impact fee district. So it does allow impact fees to be assignable and transferable. It also says that impact fee credits can be transferred to an adjoining impact fee zone or district if the adjoining impact fee zone or district will benefit from the improvement or the contribution that generated the credits. There's an interesting side note to this bill just in terms of how there was interaction between the two chambers at the end. When it was sent to the House by the Senate, the bill included language that would allow certain local governments to impose both a contribution requirement related to public education facilities and an education-related impact fee without any offsetting credit being required. And this language was apparently included to resolve an issue related, I believe, to Orange County. So when the House got the bill, it deleted the language and sent it back to the Senate. The Senate then said, we refuse to concur with your amendment to delete this language, and they sent it back to the House. And the House finally just said, we want this, sent it back to the Senate, and the Senate ended up agreeing to the deletion. But I just thought that's an interesting, give and take between example of what goes on when the bills go between the two chambers.
And particularly late in the session when these little surprise amendments emerge from one jurisdiction, one chamber, the House or Senate, and another. And that's, if we could just go back to a second for Senate Bill 410, I think it's helpful to clarify that our veto message to the governor relates to the process issue that Wyatt mentioned with respect to the amendment that preempting the county authority was added on the last day of the session, and then the bill in the House, and then the bill went back to the Senate, and they decided to accept the amendment. And then the second set of issues are more substantive concerns that Alex outlined as she described the bill. So sorry to go backwards, but I thought that was an important distinction to make.
That's okay. So the next bill I want to talk about deals with community development and housing. It's House Bill 1339. This is a much larger bill than what I'm going to be talking about. It deals with a number of issues related to mobile home parks, homeowner associations, the Florida Housing Finance Corporation. But what I'm trying to highlight here is the portions of the bill that deal with sort of the planning aspect of affordable housing. So the bill does allow local governments now to utilize a linkage fee ordinance to increase the supply of affordable housing. And the linkage fee can either be a flat payment or percentage-based fee. It does require local governments to provide incentives to offset all the costs to the developer for that linkage fee, however. It now specifically authorizes local governments to approve the development of affordable housing on any parcel zoned for residential, commercial, or industrial use. It focuses on, there's existing language that requires a local government to have a finding that there's a shortage of affordable units in a jurisdiction before a local government can adopt an ordinance to allow accessory dwelling units in an area. And this bill actually deletes the requirement for that finding. So you no longer have to do that and have that finding if you want to adopt an ordinance to allow accessory dwelling units in single family uses. Originally, both the House and Senate required local governments to adopt such ordinances, but that provision eventually got amended out in the final bill, and it's just that you are allowed to do it. It does require some additional financial information to be included relative to affordable housing in the annual reports that are submitted to the Office of Economic and Development Research by your local budget officer. And there was one clause within the myriad of changes relative to mobile home parks, et cetera, that I thought would be of interest, and it's this bill would permit a mobile home park that was damaged or destroyed by wind, water, or other natural force, such as a hurricane, to be rebuilt on the same site with the same density that was approved, permitted, and built before the park was damaged and destroyed. It also requires additional information on each different kind of impact fee to be included in the county and municipality and special district financial reports that are required under 218. And that includes the purpose of the impact fee, the schedule describing the method of calculating the impact fees, the amount assessed for each purpose in each dwelling unit, the total number of impact fees charged by dwelling unit, and then also information on each exception and waiver provided for the construction or development of affordable housing. And then there's kind of what I consider to be sort of a stick or a carrot in a stick. The bill is requiring the Affordable Housing Catalyst program to offer biannual regional workshops, and it's requiring the local officials who serve on a local affordable housing committee to attend those regional workshops. And the stick is, if you don't attend 3 consecutive workshops, it could result in the withholding of the funds from that program until your local official attends again. And this bill, again, would be effective July 1st, 2020. So there was a community planning bill that really focused on the providing standards for establishing a quorum for meetings of RPCs when somebody's going to participate virtually. But this was a bill that also included the language that was in Senate Bill 410, and is an example that I had talked about where the legislature was providing funding in preference to things that were related to the MCORS process. So this is the similar language that was in Senate Bill 410. And then there was the deregulation of professions and occupations, House Bill 1193. This might seem like a bill that we wouldn't really be all that interested in, but because it changed regulations related to occupations like hair braiders and nail polishers and other occupations like that. It added ways for out-of-state professionals to get a Florida license, including landscape architects, engineers, building code inspectors. But the part of the bill that I thought would be of interest is the parts that preempted certain regulations relating to food trucks. So as the slide shows, it preempts the regulation of food trucks, or as they call them, mobile food dispensing vehicles. Anything involving, yeah, it's like you can't just say food trucks.
Right. Orwellian.
Yeah, really. It preempts the regulation of those. Anything doing with license, registration, permits, and fees is preempted to the state. And it defines these vehicles as a public food establishment that is self-propelled, or you can move it from place to place, and it has self-contained utilities. So a local government can't require a separate license or a permit or ask for a separate registration fee or license fee as a condition of operating a food truck in your jurisdiction. And the bill also says that you may not prohibit food trucks from operating within the entirety of the jurisdiction, which to me appears to say you can't completely eliminate them. You have to at least give them some location where they can be operating. These provisions don't impact your authority to regulate these food trucks other than what I discussed was preempted, and they don't apply to port authorities, aviation authorities, airports, or seaports. And the effective date in the bill is July 1, 2020, unless otherwise provided. Some of the other sections that deal with the occupations have a specific later deadline that's provided in the bill. Food truck provisions didn't have that, so I'm read that as they would become effective July 1, 2020. So now I'm going to turn it over to Wyatt to talk about broadband and some transportation related bills. I'm hoping Wyatt is there.
There we go. Can you hear me now?
Yes.
Yes, sir.
I unmuted myself and it didn't work the first time. Okay. So I'm going to let Alex rest her voice and get some water and talk about 4 bills that are transportation or infrastructure related. I think something very interesting about all 4 is that they take on, I think, some new connotations or new thoughts in the brand new world that we are in. So talking about broadband first, House Bill 969 and its companion bill is Senate Bill 1166. If we didn't think broadband was important before, I think it's very obvious to everyone now how critically important it is, especially in our rural and underserved and areas that are not served at all currently. So this bill designates DEO as the lead state agency instead of DMS. And as noted by Alex a couple of times already, there are bills that relate to funding in the MCORS areas. This is one of those. It allows for $5 million each year to be transferred, starting in, I think, 2022, I believe, transferred from the Turnpike MCORS projects to be used for broadband infrastructure within those areas. And again, requires FDOT to give priority to those rural areas of economic opportunity that are adjacent to the 3 multi-use corridors. Next slide. So electric bikes. And by the way, on the previous bill, I wanted to point out that it passed unanimously in both the House and the Senate. This bill, House Bill 971 and its companion 1148, also passed unanimously in the House and Senate. Bicycles are becoming obviously a little bit even more popular now than maybe they were 2 weeks ago or a month ago. And there's been a question for several years as to how you define an electric bike or an e-bike. So this is now defining those systems specifically in a 3-tiered system, but the general gist is that an e-bike is treated in the same way as a bicycle. So the legislation will consider it as a vehicle in the same sense, authorizes e-bikes to be allowed where bikes are allowed, which includes sidewalks, paths, highway shoulders, bike lanes, so on. Very importantly, though, it does allow local governments to regulate the operation of e-bikes and also allows local governments who have jurisdiction over, say, multi-use paths to determine whether e-bikes are allowed on those. There has been a concern in several areas of the state on multi-use paths because e-bikes are faster, and a concern shared with on those paths when they're sharing with pedestrians or small children on a bike. So this legislation does not prohibit local governments from being able to still regulate how those bikes might be operated and where. Next slide. So continuing with this one, again, since e-bikes are considered to be bicyclists, the operator is not required to have a driver's license or title or vehicle registration. So that's an important feature. Does require that the e-bike, the electric motor, can be disengaged when the rider stops and the brakes are applied. That's a good safety measure. And again, deletes the age restriction that preventing those under 16 from using a motorized bicycle. And again, with the other bills, the effective date is July 1st. but not yet submitted. Okay, so talking about some infrastructure, Senate Bill 7018 and its House companion was House Bill 7099. This bill passed unanimously in the Senate and overwhelmingly in the House. You can notice a couple things. The utility permits is the exact same language that was in Senate Bill 410 that Alex was talking about earlier. And the other key feature of this one is staging areas for FDOT to plan, design, and construct staging areas for emergency response on the turnpike system. Also note priority consideration in finding those staging areas and setting them up to counties with a population of less than 200,000 in which a multi-use corridor, MCORS, is located. And again, also requires FDOT to develop and recommend a plan for the development of electric vehicle charging stations and infrastructure along the state highway system. There is a pilot grant program out currently for EV charging that is set up by DEP. In fact, the deadline to submit was April 7th and it's been extended to May 7th. But that is only limited to the interstate system in Florida. And so there's been some discussion about how to expand that, and this legislation will take care of that. Next slide. So as I was saying, it requires FDOT to develop a plan for the development of EV charging station infrastructure along the entirety of the state highway system. That plan is then hopefully developed and submitted to the governor by the beginning of July of 2021, and to include recommendations for legislation or anything to implement, and DOT by the end of this year to file a status report to show how this is progressing. The final feature of this bill relates to conservation or easements, allowing owner of lands for agriculture purposes to utilize that area next to a conservation easement or part of a conservation easement to be used for a linear facility. So for example, that might be related to shared use paths along MCORS, as well as some of the utility systems that may be necessary. And again, this is effective July 1st and not submitted to the governor just yet. Next slide. All right, final bill for me, commercial airports. House Bill 915, its companion Senate Bill 1258. This bill passed unanimously in the House and very overwhelmingly, although not unanimously, in the Senate. It's an interesting question as to how airports will come to be when we get out of the crisis that we're in. But, going in just up to a month ago, most of the airports in the state were recording record passengers month by month. And so there's some provisions in this that enhance the transparency and accountability for these airports, primarily in relation to the actions that they take as a board or from a staffing standpoint, contracts that are awarded for procurement, design, even who gets what shop in the airport, requiring ethics training for board members and staff beginning next year. Interesting note is large hub commercial service airports. So the bill is set up for large, medium, and small as defined by FAA. The Federal Aviation Administration defines large hubs as an airport that has at least 1% of the total boardings in the United States. And the bill requiring the Auditor General once every 7 years to conduct audits on those large hub airports and provide minimum requirements. And again, requires members of governing bodies. So in most cases, we're talking about the airport board to submit more detailed financial disclosure to the Ethics Commission and related to some disclosure requirements of the state constitution. Next slide. Okay, so some of this information has to be submitted now beginning next November, and FDOT starting in January of 2022 will submit a report to the legislature summarizing the compliance of the commercial service airports. prohibiting FDOT from expending funds for the airports in a different way related to debt service, and compliance with that transparency and accountability of the bill. I would note this says effective date of October 1st. Again, in light of the situation that we're in, the aviation industry is probably going to have one of the harder times getting back up and running. So it's possible, I guess, that this could be extended. And with that, Alex, I think we are back to you.
Okay. Let me switch the bill. So I'm going to now talk about some, I think every bill from now on is more environmental. This is the Senate Bill 178. This was the bill that I had mentioned earlier that dealt with climate change that was actually passed this session. It creates a new section in 161. And as I said earlier, it requires somebody that commissions or manages a construction project that's using state funds and the project's going to be within the coastal building zone. They're required to conduct what is known as a sea level impact projection study, or a SLIP study, prior to commencing the construction. And it has a pretty broad definition of public entity. And DEP is required to adopt rules establishing the standards for the SLIP studies. And until DEP adopts that rule, the SLIP study is not required. But once DEP adopts the rule and it's effective 1 year, then the SLIP study comes into effect. It doesn't apply retroactively to projects that commence before the date the rule is finalized. So that's important to note. And the bill does allow you to do one single SLIP study if you're going to build multiple coastal structures concurrently within one project. You end up only having to do one study at a time. So the bill identifies some of the things that at a minimum the SLIP studies have to include. Obviously, it's requiring them to be interdisciplinary and scientifically accepted. You need to look at flooding and inundation and wave action damage, and you look at either the expected life or 50 years, whichever is less. You have to take into account the potential for relative local sea level rise, and you have to look at the risk to the coastal structure and methods that you can use to mitigate, adapt, or reduce this risk. And you also have to look at analyzing the potential public safety and environmental impacts and that can result from damage to the structure. And those include in the bill, but are not limited to, things like leakage of pollutants, explosion hazards, hazards resulting from the floating or flying structural debris from the coastal structure. And then you also at a minimum have to provide alternatives for the design and the siting, and how those alternatives could impact the risk from damage and the risk and costs associated with maintaining, repairing, and constructing the coastal structure. So those are things that at a minimum have to be included, and you would see them, I would assume, appearing in DEP's rule. So once the SLIP is completed, it has to be submitted to DEP. DEP has to receive it, and it has to be published on the DEP website for 30 days before you can actually start construction. And whoever is the constructor, the state finance constructor, they are solely responsible for ensuring that the SLIP study that's submitted to DEP meets the established standards. I didn't see anything in there that provided a approval role for DEP over the SLIP studies that were submitted to them. It appears that they just have to receive it and post it on its website. It does have, DEP is authorized and does have the ability to bring civil action if construction commences without complying with the SLIP study. And if for some reason someone was able to completely build the structure or substantially complete it before the study was done, DEP can seek to recover either all of it or a portion of the state funds that were used to build the structure. The bill does say that nothing in the section can be construed to create a cause of action for failure to implement what's contained in the SLIP study. So if you complete your study and then for some reason you do not necessarily follow exactly what you said in there, it doesn't appear to allow a cause of action for damages because you didn't do it. And the effective date is July 1, 2020, unless otherwise provided in the Act. And I think that relates back to the SLIP study doesn't become effective until DEP publishes the rule, and it's been in effect for a year. So I think that's what that part's relating to. I think the SLIP study, the DEP rules and stuff like that, those requirements would become effective on July 1 of 2020.
I would just add, I think this is a really significant bill, and it's certainly, to my knowledge, Florida's first climate change bill. The Senate sponsor has been working on this issue for several years, and this illustrates the virtue of patience in the legislative process and the fact that good ideas often take time to mature, but ultimately can prevail. I would also say that proponents of the bill think that it will help with credit in insurance markets, and that Florida is finally beginning to take climate change seriously. Certainly a priority of the governor's, who is benefiting from what sociologists call contrast gain, which is his commitment and concern about these issues as opposed to his predecessors.
Thank
Immediate
you.
predecessors, I would say, i.e. Rick Scott.
Thanks, Lester, for those insights on that bill.
Mm-hmm.
The next bill is House Bill 1091. It's an environmental accountability bill. This bill actually focuses a lot on increasing the statutory penalties for violating a number of different kinds of environmental laws, but it also does include some provisions that relate to sanitary sewer lateral inspection programs for cities and counties that I just briefly wanted to touch on. And basically it's saying that it's encouraging counties and municipalities by July 1, 2022 to establish an evaluation and rehabilitation program for sanitary sewer laterals, with the goal being to identify where there's leaking laterals and trying to reduce the extraneous flow from those. So there's a number of things that these programs could include, including a system to identify where there's an issue and what are the economical ways for a property owner to make some repairs, and establishing a database to keep track of where this information and where these problems are identified, and allowing that to be publicly accessible. It also requires, for people who are going to be selling property, it requires them, prior to executing their contract for sale, if they know that they have a problem with their sewer laterals, they would be required to disclose that to a prospective purchaser. And this bill, again, would be July 1, 2020. The next bill, House Bill 73, deals with recycling material. It might look familiar to many of you. In 2018, these similar provisions were included in an overall environmental bill, which was House Bill 1149. That bill at the time was vetoed by Governor Scott because it also had been amended to include provisions allowing reclaimed water to be injected underground, and Governor Scott vetoed the bill based on that provision. And then last year, Representative Overdorf, who has submitted filed House Bill 73, filed a similar bill, which was House Bill 771. And that bill was passed by the legislature, but was vetoed by the governor because of provisions that were amended into the bill that preempted local governments from regulating plastic straws. So this year, as we go through this bill, you will notice it was kept relatively clean and passed. So third time was the charm. It requires local governments to address certain things in the contracts that they have with their recycling collectors and their material processing contractors. After October 1, 2020, your contracts have to define what would constitute a contaminated recycled material, include the strategies and the obligations that the party is going to use to reduce the amount of the contaminated materials from being collected, and creating procedures for how you're going to figure out whether containers contain these contaminated recycled materials, what are the ways you're going to handle that, and what kind of education and enforcement measures are going to use to try to reduce the amount of contaminated recyclable material from being included at all. The other part of the bill, the only part that didn't deal with the recycling, was two clauses that deal with environmental resource permit exceptions. Right now, local governments are allowed to ask somebody for verification from DEP that their construction activity meets an exception for an ERP permit. And this bill would delete that requirement. Local government, or that option, local governments would not be able to ask for further verification. And then it also revises an ERP exception related to the replacement and repair of existing docks and piers, and would now allow an exception for that type of activity if it's within 5 feet of the same location, no larger than the existing dock or pier, and no additional aquatic resources would be adversely and permanently impacted. So then the last bill I'm going to talk about in depth is the Clean Waterways Act, which is Senate Bill 712. And this was the legislature's comprehensive water quality bill. And it addresses a number of environmental issues. I'm just going to go quickly through some of those. It does transfer the on-site sewage program from the Department of Health to DEP. It requires DEP to adopt rules regarding location of on-site sewage treatment and disposal systems by July 1, 2021. It requires them to establish a real-time water quality monitoring program. It has a requirement for local governments to create wastewater treatment and/or on-site sewage treatment and disposal system remediation plans within certain basin management action plans. And those would be triggered when DEP identifies that wastewater facilities or septic systems are a contributor of at least 20% of the point source or non-point source nutrient pollution, or if the department determines that remediation is necessary to achieve the total maximum daily load as in the BMAPs. So that is what would trigger this requirement for local governments. It creates a wastewater grant program that could provide grants for projects in a number of areas, including rural areas of opportunity. It prohibits discharge from wastewater treatment facilities into the Indian River Lagoon unless you provide advanced waste treatment starting July 1, 2025. It does require Department of Agriculture and Consumer Services to actually do on-site inspections at least every 2 years for those agricultural producers who are enrolled in their best management practices program. And then prohibits the application of certain biosolids unless certain things are in place. And did you have something to add, Lester?
Yes, I was just going to add, as I explained to Wyatt and Alex, I have another commitment in a few minutes, but I wanted to emphasize this bill is really the first significant water policy bill since the late 1990s. It's been adopted by the legislature. Notwithstanding that, there are some 50 environmental groups under the auspices of the Florida Spring Council who have called for a veto of this bill. I think it's notable that neither Florida Audubon nor 1,000 Friends of Florida are among those. I think the people who support a veto feel that the bill was, to use a bad pun, watered down, not strong enough on agriculture pollution, and at least in the letter that I've seen, they're basically saying they don't trust DEP to enforce the provisions of this properly. I think it does impose a much stricter regulation of municipal sewage and wastewater systems and septic tanks. I think it's a fine first step. I think that we shouldn't be in the position of letting perfect be the enemy of good. I think it's counterproductive to call for a veto of this legislation, which was, as I say, a really significant step in the right direction, and then expect to go back to the legislature next year and improve on this. It addresses, in my view, every major source of pollution: septic tanks, wastewater, stormwater, agriculture, and biosolids. I think, as I said, this is a good bill and a good first step, and we'll be engaged on it again next year, just as we were this year.
Thanks, Lester. There are a couple other things in the bill that I just want to point out. One is that it requires DEP to conduct a study on the bottled water industry in the state and submit a report by June 30th, 2021. And in that study, the bill has a number of things that DEP needs to look at, which includes things like identifying all the springs that are being used for bottled water, the impacts on the springs from that use, the direct and indirect economic benefits to local communities from that use, and also the direct and indirect economic costs to those communities. The other part is there was a couple of other bills that included this clause that prohibits local governments from providing legal rights to any plant or animal or body of water. That was included in this bill as well. And then it also requires DEP to consider the adoption of rule for best management practices for nutrient impacts from golf courses, which is often also another contributor to water quality problems. And then briefly, real quickly, there's some other bills that we were following that have passed. The constitutional amendments, Lester, I believe, had talked about. Oh no, he didn't. You talked about Constitutional Revision Commission. There was Senate Bill 1794, which modified the process for amending the state constitution through citizen initiatives.
And I would say modified is a nice choice
term.
yes, because here's the way I see it. This bill is going to make it even more difficult for citizen ballot initiatives to get on the ballot.
Yeah.
Fortunately, it did not apply to the ballot measure that provides for open primaries in Florida. The Supreme Court has approved that, and that will be on the ballot in November of 2020, and it will turn politics in Florida upside down, because some 2.8 million, I think, people who are registered with no party affiliation will now be able to vote in either the Democrat or Republican primaries, whichever they choose. Hugely significant.
Yeah, and with respect to this Senate Bill 1794, I believe that there's a coalition of voting rights groups that are calling for a veto because of the concern about it imposing a whole series of new restrictions on the ballot initiatives.
That's correct. Led by the League of Women Voters.
Mm-hmm. And then the last thing I wanted to point out, under the bill that was dealing with transportation network companies, this bill preempts the regulation of luxury ground transportation network companies and their vehicles and their drivers to the state. But it also authorizes any transportation network company driver to contract for the installation of digital advertising devices on the vehicle that they're using when they're working as the TNC driver. And I went and looked at the legislative staff assessment of the bill, and the staff assessment indicated that because previously TNC drivers and transportation network companies and their cars were preempted to the state, and this bill is just adding luxury ground TNCs, that these digital advertising devices and the regulation of those could also be preempted to the state. So that was an interesting development when I went back and read the legislative staff reports. So that kind of covers all of what we had wanted to talk to you about today. Wyatt, I'll turn it back to you if there's any questions. The SAM event, as Wyatt had said earlier, has been submitted for 1.5 SAM credits and 1.5 law credits, and that's the event number at the bottom of the screen. So Wyatt, I'll turn it over to you.
Great, thank you. Alex, we had a series of questions that came in. I think I've tagged about 8 or 9 at the moment. And I'm going to guess that on the majority of them, we probably can't answer them right now offhand. So I'm wondering if we would be able to, I'm hoping, catalog these questions, put some responses together, and also put that up on the website along with the slides.
Yeah, we could do that.
Okay.
We may not still be able to answer them with
Correct.
more time, but
yeah,
do our best.
Yes, and that's what I mean. I'll take the first one that jumps up as the one that relates to that is best. Question on Senate Bill 410, and what does the definition of next plan amendment mean? I know we've had some discussion about that, and also I asked a couple of our LPC members. Does that mean if a local government is making a small plan amendment or a large plan amendment in 6 months, do they have to put this stuff about the property rights element in then, or is it at their next year base? What I've heard was that folks are going to be looking to DEO for direction on that, but I don't know if Alex or Lester, you have anything different.
No, I mean, the bill doesn't define it. So I think, either working with your local attorney or asking for direction from DEO would be the appropriate step to take.
Okay. Yeah, so we have a couple of questions about 410. There was a question about food trucks related to whether local governments can require the trucks to still get a business tax receipt in order to be able to operate. There was a question about the definition of current or pending permits, and whether that could include projects that are in the site plan review process. I'm just going through the list of questions. There was a question about affordable housing, and how affordable housing can be approved in areas that are not zoned for residential. There a question about how much money is set aside in this budget for MCORs. I don't know that they set up anything specific that would be different than what was in the last legislative session, but we can look at it. And then there was a question about elevation requirements for House Bill 1339, whether it preempts local or federal requirements on replacing mobile homes that were damaged. And then I think I had maybe one more question that has just come in that I have not been able to catalog yet. But if we get the whole set, Alex, and we go ahead and put that up on the website with whatever best answers we can, I think that hopefully will work for folks.
Okay.
Oh, the final question was about Senate Bill 426. So that's something we'll have to look into regarding rural development orders, it appears.
426?
Well, it's kind of hard to see on these questions. It's a very small little chat box. So
yeah, that was an economic development bill that was submitted or filed by Senator Monford, and it dealt with allowing it changed some of the divisions within DEO, and it allowed regional economic development organizations to be able to use hiring of professional staff to perform certain services was part of the concept of building the professional capacity, so they could be using money for that. So I'd have to look and see what the specific question was.
Okay.
See if
well,
we could answer it.
And when I said development orders, that was blending two questions together. So my apologies.
Okay, because I was gonna say that didn't have anything to do really with the development
again,
orders.
the small little question box makes that hard to see.
Okay.
But yeah, we'll go ahead and get that summary up. I know there was a question early about how soon this would be up. And I responded that we thought we could get the slides up in the next few days. The recording might take a little longer, but we will get
the questions might take a little bit longer.
Correct. That's what I was going to say, is now that we're talking about the questions, that also may take a little bit longer. We're going to go ahead and try and do some research on some of these.
Right.
But I think that's all I have, Alex, other than to thank both you and Lester for your hard work in putting this presentation together, as well as all of your hard work during the session and in our previous sessions in years past. So we very much thank you for everything you guys both do for the chapter.
And you will be getting, as an attendee, you will be getting a survey to fill out, an evaluation of this webinar. So we hope that you'll take the few minutes to fill that out and send it back. Okay. And I guess with that,
we say thank you and have a great afternoon.
Bid you adieu and have a wonderful rest of your afternoon and week.
Thank you, everyone.